The 5 members of Canada's 2018 World Junior Hockey team facing sexual assault charges have chosen a trial by jury rather than by judge. The 5 defendants, Dylan Dubé, Carter Hart, Michael McLeod, Cal Foote, and Alex Formaton, are each facing 1 count of sexual assault, with McLeod also facing a charge of being party to the offense. What is the difference between the 2 trials, judge and jury? With us this morning is criminal lawyer Boris Patensky to explain the difference. Good morning.
Good morning, Anne-Marie. It is a vast difference. In the case of a jury trial, you're going to be tried by 12 members of your community who will ultimately decide whether the Crown has proven the case against you beyond a reasonable doubt or not. And when you have a trial with a judge without a jury, that's one person who makes a decision based on the evidence that they hear. But usually, you know very little in advance about the jurors or the judge, but you have 12 people that have to be convinced unanimously in order to find guilt. And that's why in many cases like this, where credibility is going to be the key component, people do elect to have trials by jury.
Yeah, trial juries are an option for those who have committed serious offenses like sexual assault. And typically when a defendant elects for a trial by jury rather than by judge, what is the thinking behind that strategy?
For one thing, it allows you to keep your options open. You do have the right to change your mode of trial more flexibly if you make it an election to be tried by a jury. So there could be developments between now and the time of the trial that would make these 5 individuals change their mind. If you make an election to have a trial without a jury, it's very difficult to go the other way. So this, if nothing else, it keeps your options open a little bit longer. But more importantly, like I said earlier, it's a tough task to convince 12 people to be unanimous about your guilt. And so if you have these life-changing consequences at stake, as of course all 5 of them do, then you want to sometimes make sure that the Crown can't get a verdict of guilty unless there's 12 people that are convinced unanimously against you. And that's what often people choose to do.
In Ontario, jury trials are held at the Ontario Superior Court rather than in provincial court. How could that have factored into the decision to have a jury trial?
I don't think that factors at all. I mean, that's just the location of where the jury trials are. There is an element of location of trial right now. Of course, everyone's being tried in London, Ontario, and that may remain that way. But when there is a trial by jury, one of the questions that will have to be assessed at some point is whether or not there should be an application to change the venue to a location that perhaps has less publicity, less of a percentage of its members of the community that have already formed an opinion about the case. I'm not saying that that's what's happened in London, but again, when you have a trial by jury, the location of your trial could be changed in the right case in the right circumstances. You
mentioned this already, Boris, but the players' lawyers will be able to apply for a change of venue if they want to. Given the prominence of this story in London, Ontario, I mean, it's really become a national story, but given the fact that it is a local London story, how do you expect a change of venue could be applied for?
Well, you're quite right, and it's going to be difficult to find any location within Canada that doesn't know much about this case. It's a case that, rightly so, has received quite a lot of publicity. So I doubt you'll find a community where people just haven't heard about it. But in a place that's larger, where perhaps there's fewer conversations around the water cooler about it, you might be able to have a greater percentage of the people that have yet to form an opinion about it. It's not the only story in a larger place like Toronto or Vancouver. I mean, it couldn't move out of Ontario, but there are many places within Ontario, perhaps, where it's not the subject of conversation to the extent that it might be in a place where the event actually took place. Having said that, it is a tough test to get a change of venue, and I'm not suggesting in any way that this is likely to come down the pipe, but it is an option that everyone's going to have to consider.
Just curious, Boris, does it change anything procedurally within the court when you have a trial by jury versus by judge? Does it change who gives testimony or who has to appear?
It doesn't change who has to appear, but there are definitely some shortcuts that you would take in a judge-alone trial. There are things that get explained to the jury. There's more background that's developed. The witness testimony might be a little bit more, just longer, for lack of a better word, because when you have a trial by a judge alone, there are certain things that you can presume the judge already knows. They'll have an understanding of certain legal principles. And of course, the jury has to be instructed. So jury trials on average, will take a little longer than trials without a jury. But that's, frankly, the price of doing justice correctly.
Boris, thank you for this.
My pleasure. Thanks for.
Hey, thanks for watching. If you liked this, be sure to subscribe here, or you can check out more Your Morning videos right here.